few days ago, I published a presentation going to the fiercely fought in limine motion concerning the alibi defense. The state's position is that Mr. Kohberger has not complied with what the law says he was required to do when he was served with a demand for alibi. If he intended to raise an alibi defense, the state back on May 23rd, 2023, asked that he respond with the details that are contained within Idaho Criminal Rule 12.1 and the statute governing the defense of alibi, which is Idaho Code 19519. We have a poll currently on our community page that I invite you to participate in. The state filed a motion in limine back on February 21st, asking the court to render a ruling that Mr. Kohberger has not complied with Idaho law regarding the defense of alibi, and to rule further that he be prohibited from entering any evidence onto the record, either directly, indirectly, on direct examination, by cross-examination, through anyone but Mr. Kohberger himself. The defense has come back and raised some issues. They are opposing it. They feel that they have partially complied thus far with their responses. What Judge Hippler has before him is an obligation, I believe, to look at two things and two things only, and then apply the facts to these two things. And by things, I mean legal authority. First, both parties seem to agree that Idaho Criminal Rule 12.1, which was enacted, it was promulgated by the Idaho Supreme Court. That's where this rule comes from. It says here, according to the Idaho Supreme Court, Idaho Criminal Rule 12.1, notice of alibi. Quote, if the defendant intends to rely on the defense of alibi, the defendant must, not may, not could, not should, must, mandatory, in other words, comply with Idaho Code Section 19519. This is a statute passed by the Idaho legislature. It is the law of the state of Idaho. And if the citizens of Idaho do not agree with this law, and it is incumbent upon them to go to the legislature to try to convince them to change this law, and for the legislature to change the law. Until then, this is the law of the state of Idaho. Let's take a look at what this rule says one more time before we go to the statute. Number one, Idaho Criminal Rule 12.1, notice of alibi. If the defendant intends to rely on the defense of alibi, the defendant must comply with Idaho Code Section 19519. Let's go now and look at the language of the statute. And we're looking at it. We're not attorneys licensed to practice law in Idaho, nor do we claim to be legal professors of law or anything else. We're just going to look at this and apply some common sense here. If it appears to be unclear, giving Judge Hippler the authority to change the language of this statute in any way, which, by the way, the defense has not provided any legal authority for Judge Hippler to rule in any way but how that rule says, 12.1, and what the statute says. Let's look at Section 19519, Notice of Defense of Alibi. Bear in mind that the defense was served with a demand for alibi to raise this defense May 23rd, 2023. It is now April 1st, 2025. These hearings will be held on the 9th, possibly going into the 10th of April, which will be almost 2 full years since the notice of demand of alibi was served. It says, notice of defense of alibi, part 1. At any time after arraignment before a magistrate upon a complaint and upon written demand of the prosecuting attorney, the defendant shall serve within 10 days or at such time different, at such different time as the court may direct upon the prosecuting attorney a written notice of his intentions to offer a defense of alibi. Such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offenses and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. There is nothing within the 10 days after May 23rd, 2023, that authorized the parties to relax this 10-day statutory standard. In other words, if you were to go on the court docket and look for an order from the 23rd to 24th to 25th to 26th, 27th, 28th, 29th, 30th, 31st, 1st, 2nd, to see an order that allowed the parties to relax this part of the statute before that 10-day window expired, it is non-existent. Let's go on to part 2. 2. Within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial, unless the court otherwise directs, the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom the prosecution intends to rely to establish the defendant's presence at the scene of the alleged offense, and in any other witnesses to be relied on to rebut testimony of the defendant's alibi witnesses. So this is contingent upon the defense's complying with the statute. Some people have looked at this and said, this gives Mr. Kohberger up to 10 days before trial to serve his notice with specificity of where he was and who the witnesses are. Look at the words of this statute. It deals with the prosecution then. There's nothing here that says that you can go ahead and serve discovery. You can wait until 2 years later. You can depend on an expert witness to provide an opinion. This talks about facts, clear-cut facts. The other issue that is now raised is if Judge Hippler, and we don't know how he's going to rule, but let's just say he rules in favor of the state. Mr. Kohberger has now admitted willingly where he was during the late evening hours of November 12th into the early morning hours of the 13th of November 2022, when the catastrophes happened at 1122 King Road. He was under no obligation to say a word. The defense raised his Fifth Amendment privileges early on, back in December of 2022 for him. He stood silent at arraignment, but he stopped standing silent for this alibi defense. Is it a doomed defense? Is it winnable? Let me know. Not based on emotion, not based what you think the statute should say, but facts pinpointed to the record as to why you think this in limine motion should be granted or denied. This is Kathy. Thank you very much for joining us here today.